I wanted to get into some of the procedure of how things happen. Um, Maybe it would be useful if you could walk us through a case, not just what happened, but how it goes through the process of going through the court. You mentioned the death penalty cases. That was a major case when you first joined.
Sure, but a better way to illustrate the way the court worked would be to take an individual case where there has been a trial and the case is decided by the trial court, and then there's an appeal by the losing party to the appellate division, and the appellate division either affirms the trial court or reverses the trial court, and it raises an issue of law. Perhaps the issue of law might be something as simple as when the statute of limitations runs out in a medical malpractice case in which the surgeon left a sponge in the body of the patient. The patient didn't know about it. The ordinary statute of limitations is 2 years, and the question might be, to take a question from a case the court decided before I joined it, does the statute of limitations run from the time that the negligent act occurred by the doctor, or should the 2 years run from the time that the patient knew or should have known that the doctor left a foreign substance in her body? So let's say the appellate division ruled in the case that the statute of limitations, the 2-year statute of limitations, began to run on the day that the doctor performed the operation. And the patient loses the case because she didn't file her suit within that 2-year period. She filed the suit, let's say, in the 3rd year after she discovered that there was a sponge there. And the losing lawyer would then file with the Supreme Court what we call a petition for certification. And it's basically a legal argument that says, "Dear Supreme Court, you should take this case because it was decided incorrectly below. It raises an issue of significant public importance that this court has not ruled on yet, and the bar and the public need the Supreme Court of New Jersey to resolve this issue once and for all so the lower courts know how to decide it." We have a very large set of rules that govern the courts of New Jersey and the practice of law, and there's a special section of the rules that govern proceedings before the Supreme Court. And those rules indicate that in order for your appeal to be heard by the court, you don't have an appeal as of right unless there was a dissent in the appellate division. The appellate division generally decides cases with 3 judges, sometimes with 2. But when there's a 3-judge panel and one of the judges dissents, then there's an automatic right to appeal to the Supreme Court. But if the appellate division was unanimous, then litigants in the state don't have the right to appeal to the Supreme Court if they lose. And that includes criminal defendants who have been convicted and lost their appeal to the appellate division. Our court rules say that in order for your appeal to be heard, the court has to grant your petition for certification. And the way that works is that you would file your petition, your adversary, the lawyer who won in the appellate division, would file his or her answering brief, and then you would get a chance to file a short reply brief. And those papers along with the appellate division decision and the trial court record, would be collected by the clerk of the court and distributed to the justices. Now, because the justices get a large number of cert petitions, the practice in our court when I was there, and I assume it's still the practice, is that the justices review at a single conference, and they typically have held conferences on Tuesdays every other week. The week between conferences is the week in which oral arguments are conducted on Mondays and Tuesdays. So a typical cycle in a month would be first week, Monday and Tuesday oral arguments, next week conference on a Tuesday, next week oral arguments, next week conference. At the conferences, in my day, we used to consider, on average, 60 petitions for certification. Because that's a lot of paper to read, the court's practice was to divide the 60 petitions into 3 sets of 20 each. And we would form within the court 3 teams of 2 justices, excluding the Chief Justice. So 2 justices would read every 20 petitions. Another 2 would read another 20, another 2 would read another 20. At the conference, the team of 2 justices that had your cert petition about the sponge would tell the court about their 20 cert petitions. Normally, the 2 justices would alternate. One would take one would take the next. So one of those 2 justices would tell the other 5 justices about this case with the sponge. Typically, the 2 justices on a team would have consulted the day before. They would have read their 20 cert petitions. They would have asked their clerks to do whatever research they wanted to have done. And then they would have called each other on the phone and gone over each of the 20 cert petitions and discussed whether or not they agreed on whether to recommend a grant or a denial to the court. Most of the time, the 2 justices agreed because many of the cert petitions are routine. Many of them are criminal appeals that don't involve significant issues. Sometimes they disagree, but assuming they agreed, at the conference, the one justice talking about this case would say to the court, Joe and I recommend that the court take this case. We think it's an important case. It involves what triggers the statute of limitations in a medical malpractice case, the date of the negligence or the date on which the patient reasonably should have discovered that there was negligence in her treatment. And we think the court should resolve it. The rules require 3 votes for a grant. So it's a 7-member court. So even if 4 members don't agree and don't think the case is worth taking, don't think it's important enough, or they think it's correctly decided and there's no need for the court to write about the issue, if there are 3 members that vote to grant, then the case is docketed. The petition is granted. It's docketed for oral argument. That oral argument typically doesn't occur for 3 or 4 months because in the time between the grant of the cert petition and the time of the oral argument, one of the clerks for one of the justices is assigned by the clerk of the court to write a bench memo about the case. And that bench memo better be good. That bench memo is for the benefit of every member of the court. And so that law clerk, and we used to work very hard picking our law clerks. I would get sometimes 200 applications for the 3 law clerk jobs. And I would interview 20 or 25 applicants. And we would try really hard to get very, very top flight law school graduates to serve as law clerks. So that law clerk would then read the briefs, read the case law, not only in New Jersey, but around the country, read any secondary sources like articles in law reviews, read treatises like the Restatement of Torts, and put together a very comprehensive memo that includes a very detailed summary of the trial record, an explanation of how the trial court decided the case, how the appellate division decided the case, a summary of the arguments of counsel on both sides, a review of the case law in New Jersey and around the country, and then finally a recommendation to the court about how the case should be decided. A very important part of our work, because with the caseload that the court has, it would be redundant for every member of the court to do that kind of research for every case that we hear arguments in. So the fact that one law clerk, and law clerks vary in skill and in their ability to write and in their analytical ability, but one law clerk writes the bench memo, and then the members of the court, the week or so before oral argument, will reread the briefs and the bench memo, and in my case, and I assume most of my colleagues did the same, dictate a little memo to prepare for oral argument. And typically, we come on the oral argument day to hear the argument in that case, never having discussed the case except 3 or 4 months earlier when we voted on the cert petition. And most of us have forgotten that discussion by the time the case is ready for argument. And on the day of argument, the case is called. The lawyer who lost in the appellate division, the appellant, argues first, presents his or her argument. The members of the court are free to interrupt, to question. We have a rule called the 5-minute rule. And under that rule, if you ask for an uninterrupted 5 minutes, your wish is granted and you can speak for 5 minutes. No member of the court interrupts you. On my court, and I think they still have the same practice, if any justice broke the 5-minute rule, that justice would be fined. We used to have a kitty. And on my court, Justices Clifford and O'Hearn would enforce the 5-minute rule. Justice Clifford would determine how many minutes you had interrupted the lawyer for, and would signal to Justice O'Hearn with his fingers, and Justice O'Hearn would record that you owed $1 for each minute. And periodically we would pay up, and at the end of the term we would have a fund for an end of term celebration. So that was how we enforced the 5-minute rule. But you get 5 minutes uninterrupted if you ask for it. You have an argument. You respond to questions. Your adversary delivers his or her argument. If you ask for it, you get a few-minute rebuttal. And the court, on an oral argument day, Monday and Tuesday typically being the oral argument days, will hear 8 or 9 cases and not discuss them, because you're on the bench most of the day, and by the time the arguments are over, you're tired and you want to go home. You won't discuss them until the conference the following week. That's the conference at which you review cert petitions in the afternoon. But in the morning of the conference, the Chief Justice will first convene the court to talk about the cases that were argued the prior Monday and Tuesday. And everybody comes to court prepared to vote on how the case should be decided. I must confess that I used to have a Monday conversation before the conference, almost always with Justice Clifford, sometimes with Justice Clifford and Justice O'Hearn, just to get a sense of how they were leaning in some cases, and they would get a sense of how I was leaning, and sometimes we'd talk about them. I'm not saying I never spoke to anybody else, I'm sure I did, but as a matter of practice, the three of us would consult. I don't even remember if Justices Clifford and O'Hearn would talk, but I would always talk to Justice Clifford and often talk to Justice O'Hearn. That doesn't mean that we necessarily agreed. Mm-hmm. It just meant that we understood why we disagreed. Mm-hmm. So the Chief Justice would call the case. Let's say this is the Scully case, because that was the name of the doctor in the sponge case that I remember, Fernandi v. Scully. And he would select one member of the court to start the discussion. We sit around the conference table in strict order of seniority. So on our court, the Chief Justice was at the head of the table. To his right was Justice Clifford. Across from Justice Clifford was Justice Handler. To Justice Clifford's right was Justice Pollock. Across from him was Justice O'Hearn. To Justice Pollock's right was Justice... I'm getting this wrong. Wait a minute. It wasn't that way. It was Clifford, Handler, Pollock on one side, O'Hearn, Garibaldi, and Stein on the other side of the table. I think that's how it went. But in any event, the Chief Justice would call on one of us at random, and then we would go around the table in order of seniority, starting with the person that spoke. So if Justice Handler spoke, he'd be followed by Justice Pollock, and we'd go around the table. Chief Justice would speak last, except in unusual cases when he would ask to speak first, which he often did in big cases, and it was always a matter of great laughter on the court when the Chief Justice would speak first and nobody would agree with him. But typically, we would go around the room, and the first time around there would usually be a consensus. You'd have 7 votes to affirm or reverse, or 5 votes to affirm and 2 dissenters, but you'd have a consensus. Sometimes you'd have to go around again because the consensus wouldn't be clear, or there was still more to talk about, or people had questions, and so there would be an open discussion. At the end of the discussion, we would know how the court was going to decide the case. We would know what the vote is. Might be 6-1, 5-2, 4-3. The Chief Justice had the prerogative of assigning the majority opinion, and he would decide who should write the opinion. Now, this is not a subject I'd ever discussed with Chief Justice Wilentz, but I watched him for 10 years, and there was often a reason for an assignment. Sometimes the reason was, well, this was an area of the law that this person knew particularly well. Or this was a very controversial case, and the result was, so to speak, a liberal result. So it would be good to have a Republican member of the court or a conservative member of the court write the opinion, that kind of thing. Or in the right to die cases, the assignment was to Justice Garibaldi, and although that was never discussed, it might have been prompted by the fact that she was one of the Catholic members of the court, and it was a controversial issue among the Catholic clergy. Chief Justice Wilentz assigned to me the first death penalty opinion that resulted in an affirmance. That was the Marshall case. Robert Marshall was the guy who hired a killer from Louisiana to ambush his wife on the Garden State Parkway. He never told me why he assigned it to me. Our court had reversed 30 death sentences in a row before I wrote State versus Robert Marshall. But it might have been that I was coming up for reappointment. That is, my first 7 years on the court was winding down. I think I had another year to go. And there was a lot of hostility to the court because we had been reversing death sentences left and right. We had not affirmed any. And Chief Justice Wilentz might have thought that it would make my reappointment smoother if I wrote the first death penalty opinion. Do I know that that's what he was thinking? I have no idea. Is it a good bet? I think it was. But the vote in Marshall was 5-2, so it could have been assigned to, he could have assigned it to himself or to any one of 3 other justices. He selected me. So the assignments sometimes were for a specific reason. Sometimes it was a matter of your workload. Mm-hmm. One justice might have fewer cases left to write than others, and the Chief Justice would keep track through the clerk of the court who had a heavier load and who didn't. In the course of a term, there might be a couple of blockbuster opinions where whoever got that opinion knew that they weren't going to have any free weekends for a long time. My Marshall opinion, I think, was more than 250 pages affirming that death sentence. And so he would take those things into account because the court would try to finish its opinions by the end of the term. And some members of the court were spectacularly efficient. I remember riding the elevator after conference down to the parking area with Justice O'Hearn, and he would often have a legal pad in front of him in the elevator, and he always wrote on a diagonal, and he would start writing the opinion he was assigned in the elevator. And he had an incredible ability to turn out opinions promptly. There was one occasion that I guess I'm the only one left to remember it, but after a conference, Justices Clifford, O'Hearn, and I went to Joe's Mill Hill, a bar right behind the Justice Complex that Governor Hughes used to like, I'm told. And we had a couple of beers, and we got to talking about one of the cases, and the 3 of us agreed after the conference that the result that we reached at the conference may not be right, and that maybe the court ought to decide it differently. And Justice O'Hearn said, well, let me take a crack at it. Let me see if I could write something up that makes sense. And I walked into my office the next morning at 9 o'clock, and the phone was ringing, and it was Justice Clifford. And he said, just take a look at your inbox. O'Hearn has produced that draft of an opinion we talked about yesterday at Joe's Mill Hill. So he was the quickest opinion writer on the court by far. Justice Garibaldi also was pretty quick. Justice Clifford sometimes was way behind. I was somewhere in the middle. Justice Coleman was pretty quick. Justice Handler tended to write long opinions. But all of us were blessed because we didn't have to worry about errors in grammar, and we didn't have to worry about errors in the form of citations. Judges and lawyers have the benefit of what we call the Harvard Blue Book of Citations, and it tells you all kinds of arcane things. For example, if you're citing 10 cases in support of a proposition of law, The Blue Book tells you the order in which you list the cases. Very definite rules. If you use a signal like see, the word see a certain case, and it's underlined, it means one thing. If it's not underlined, it means something else. So the Blue Book is sort of our Bible. And no one knew grammar or the Blue Book better than Justice Clifford. And so during all of my years on the court, he edited for style, for grammar, for Blue Book, and sometimes for substance, but mostly for style, every member of the court's opinions, majority and dissent. I remember the day I got back the first opinion I wrote for the court, and on the front page there was a little note from Justice Clifford, and it said, "Proud to join, RLC," which meant that he liked the opinion, he would join it. The rest of the pages were a sea of red marks as he went through all kinds of little style errors. He was a nut about the proper use of the word only. I only eat crackers in bed, or I eat crackers only in bed. And he was always telling you to put the only later in the sentence to make sure it was clear that you don't only eat crackers in bed, because of course you sleep in bed and you read in bed too. He was the only member of the court who really understood the difference between that and which. And nobody could write an opinion that didn't have corrections from Justice Clifford about when you would use that and when you'd use which. It's too complicated to explain now, but there's a wonderful discussion in Fowler on English usage, which he got me to memorize. But he did it not only for me, but for everybody, including the Chief Justice. Mm-hmm. And everybody was very appreciative, very grateful. That probably explained why he would finish his assigned opinions latest in the term, because in addition to writing them, he had to edit everybody else's. And that was really time-consuming and difficult. And what it did for the court was that it just raised the quality of our written work. It made our written work better and contributed to the really wonderful reputation that the court had during those years around the country as one of the leading state courts in the country. So it was a labor of love for him. I mean, he used to tell me that he edited Time magazine when he read it at home. That was just the way he read, but that was distinctive. So the process didn't end with the assignment of opinions, because as I'm explaining the process, if you got the opinion in the Sponge case, and let's say it was assigned to me and I had to write it, I would circulate it. That is, when I was finished with it, my law clerks had checked it, and everybody was satisfied in my chambers that it was as good as it could be. I would send it to my 6 colleagues. And then I would get back, in addition to Justice Clifford's red lines, I would get back comments, usually from everybody else on the court. And the comments might be, "Count me in," or I'm with you, that kind of thing. Others might have a couple of little suggestions. Nobody ever had as many suggestions as Justice Clifford, but you always got. And then at the next conference, the author of the opinion in the Sponge case would report to the court, "I've heard from everybody, and Justices Handler and O'Hearn think that the section that deals with this part of the opinion isn't clear enough, so I'm going to recirculate the opinion. I'm going to fix it up because it's not quite ready. Or, on the other hand, if everybody agrees with it and there's no dissenters, they might say file it. And then I would write a letter to Steve Townsend, the clerk of the court. The current clerk is Mark Neary. And I'd say, here's my opinion in the Sponge case. It's ready to be filed. And then Steve and the clerk's office would write a little syllabus, which meant they would write an introduction to explain what the case was about. And then they would release it, which meant that the press would get it and it would be available for publication. The Law Journal would get it, and it would be published in the hardcover books, the New Jersey reports that contain all of the court's opinions. If, on the other hand, the opinion wasn't ready and had to be recirculated, or if there was a dissent that hadn't been circulated yet, we'd hold the opinion until the dissent was ready, or until the opinion had been recirculated, until it was cooked, until everybody had had their say, until everybody had had a chance to look at it, to comment on it, to tell you whether they liked it, whether they didn't like it, what they agreed with, didn't. And the final product, the end product, really represented the collective work of the whole court. Even though the opinion was drafted by the opinion writer, it was a collaborative effort, and it had the insights and observations of every member of the court before it got released. And in some cases, that was a long process. You can imagine in an opinion that's a couple of 100 pages, you can have a lot of comments from a lot of people. And so it was a very deliberative, collegial, sometimes time-consuming, sometimes arduous process to get an opinion, to get a case from the day that you grant the cert petition through oral argument, through the conference, through the assignment of opinions, through the bench memo, through the drafting of the opinions and the dissents, through the review process and the collaborative process, into the final end product that is sent out to the public. So that's sort of the way we decided cases. It was, I think it was a very careful and excellent process. It produced good work. And it had the benefit of 7 heads, which are better than 1.